You can't say that this Constituent Assembly is outside the Constitution. It's within the constitutional framework because it refers to it. Yes, your argument that once the Constituent Assembly is no longer there, what will be the position with regard to clause 3 to 370 is something which we'll have to examine. With reference to the procedure you have, with reference to, because the judgments itself, many of the constitutional bench judgments itself says we are not examining that issue. We'll have to examine.
No, only worry is, only with permission of the learned AG, the worry is, suppose this exercise would have been undertaken in 2007, in 57, when Constituent Assembly was in existence. Suppose it would have recommended that don't abolish or don't abrogate or apply with modification that none of the provisions of the Constitution of India would be applicable, or never apply fundamental rights with that modification. Would, I'm putting a question to myself, the President of India will be denuded of its powers? Was it intended that by not recommending not to abrogate, it would become permanent?
We have taken that argument.
In other words,
But proviso will no longer be applicable after the Constituent Assembly is not there, but that will not deprive the President of his power under clause 3.
in other words, if the object and the role of Article 370 is essentially and fundamentally a constitutional integration process, anything which emanates from the Assembly, to the contrary, as a way of negation of the integration process, would be forbidden under the scheme of Article 370. You can't have a negation there.
Mr. Tony, you extended that argument,
Yeah.
therefore the questions arose. You extended the argument to say recommendation only means advice, and even no advice. Suppose the Constituent Assembly was, that's assuming that the Constituent Assembly was,
Therefore,
There-
I quite see. Therefore,
that,
what I'm
that
trying-
part, the extension part is the one which is.
Therefore, we have to probably understand the context in which why this provision was at all enacted. The constitution integration process repeated was the only mantra under Article 370. And everything around it revolves around it. 371 A, B, the Parliament to be enabled to legislate, extension of provisions of Constitution, they all revolve around this central theme.
See, the only thing is in relation to Jammu and Kashmir, one thing is very clear from reading Article 370. It expressly recognizes the instrument of accession. Categorical recognition of the instrument of accession in Article 370 itself. Second, a categorical recognition in Article 370 of the process of the formation of the Constitution of the state of Jammu and Kashmir. Third, a categorical recognition of the status of the Constituent Assembly of Jammu and Kashmir. So therefore, it's not that these were instances which were taking place as a part of the realpolitik in that state. The IOA, the Constituent Assembly, the process of constitution formation in Jammu and Kashmir, they are expressly recognized in Article 370.
You're right. My editor
So they have been conferred with a certain constitutional recognition, if not a constitutional status, a constitutional recognition in Article 370.
I just want to enter a small caveat because the historical narrative about what happened in the rest of the country towards constitutional integration. As I said, essentially the process was one and the same. Constituent assemblies.
You are right,
formation
Mr.
of
Attorney
states.
General. You are right, Mr. Attorney General, to the point that this was in aid of constitutional integration.
Yes,
And as we see that integration was taking place by and by
yes.
from 1957 right through to 2019. So subjects which were completely excluded to the Parliament were brought in within the purview of Parliament. That was also a clear understanding of the constitutional movement towards greater integration of Jammu and Kashmir into the Republic of India and the Dominion of India originally, then the Republic of India. So there was undoubtedly a gradual and imperceptible integration apart from the unconditional accession to India, which we saw right at the outset in Article 3. There's no difficulty about that. But the only point really is this, that there are two ways of looking at Article 373. If the proviso can't apply, we keep 367 apart for a moment. if the proviso to Article 373 cannot apply, does that mean that the power under the substantive part of 370 is
Is lost.
completely denuded or lost?
No. The answer will
Or
be no. The answer will be no. I'll try to.
that's the
The
that's
power
the
is
issue
not
which we have
lost.
to- And if that power is not lost, is it a unilateral power then which can be exercised by the president? What Parliament really did was this. They didn't have a constituent assembly in the state of Jammu and Kashmir. There was no constituent assembly. They were exercising this power to abrogate. They followed the 367 course, obviously, with an idea that in the absence of a constituent assembly, there's no legislative assembly in the state. You go to Parliament, which in that sense represents the broad diversity of them.
Democratize the decision.
You have the Rajya Sabha, which is a council of states,
Correct.
which represents the overall diversity of the nation. You have the Lok Sabha, which consists of elected representatives of the nation. But in that process, there's one, I wouldn't say casualty, but one dilution. And that dilution is the role which was ascribed by the proviso to Article 370(3). Now, that role can, as you are trying to sort of elaborate, that role is merely recommendatory. Merely because that role is recommendatory does not mean that it can be dispensed with, because the Constitution provides for a recommendation. When a Constitution provides for a recommendation, we can't say that, well, even if there's no recommendation, that's fine, you can override it.
My endeavor is.
Can I just add one thing? Sorry.
I'm sorry.
I'm so sorry to interrupt. You see, after you amend 367, you say legislative assembly is equal to constituent assembly. We have to take it to the logical conclusion.
Right.
We've accepted that it exists, my lord, but.
That's right. That's how it has.
But my lord, only one question, my lord, and your lordships can consider this, my lord, during this holiday. My lord, suppose in 1957, at the time when the constitution was framed, Constitution of Jammu and Kashmir,
Yes.
and the Constituent Assembly was dissolving itself, last speeches were made, etc. Suppose it would have said that now in exercise of our powers under 370, sub-article 3, we recommend the president that the constitution which we have framed will provide for a semi kind of monarchy, and now therefore you delete 370. Lord, would it not go against the very spirit with which 370 was incorporated? That it has to be temporary and you are an integral part, because 370 sub-article 3 says, notwithstanding anything contained in the foregoing provision, meaning thereby 1 and 2, instrument of accession and article 1 being applicable. So, Constituent Assembly technically was not bound by 1 and 2. It could have said, then, my lord, would the president be completely denuded and act as per the desire of the Constituent Assembly? It cannot be, for the simple reason that the debates in the Constituent Assembly repeatedly say that this is a temporary provision.
So that's why I said you can't.
You don't have to refer to the debates.
So that's why.
Even the.
Until
That's
unless
why
we
I
ignore
said
it.
there can't be a negation principle read into the proviso. A principle of negation whittling down the entire scheme of Article 370. You can't read it into the proviso.
Let us say, brother, that as Sheikh Abdullah at that time wanted that independence resolution being passed. That's why you put in registered of the assembly.
It's the very, that answer is given in the Article 370.
And they, had they proposed, then the president is not bound.
No, that proposal is not, this will be contrary to Article 370.
That's right.
May I have your lordship's permission in support of this submission?
Contrary to Article 1 also.
Reading material can be shared with,
Kashmir is an integral part of it.
That's all right.
Good question.
some reading material can be shared with your lordships and then.
No, nothing in terms of reading material, Mr. Attorney.
We have enough reading material with us.
Now we will go by churning material, which we have at the bar.
I didn't want to.
Because then in rejoinder, we'll get a couple of thousand pages, Mr. Attorney, and we only know what difficulty that poses at the end to us.
Coming through that, I understand.
If you are more accurate list of names.
These are some
We put that discipline on you because we realized what could happen.
No, but what happened?
That was,
No.
So the facts which are on record in the words of Sardar Patel.
This is please let us not get into that. I don't think,
says,
I don't-
Ms. Sybil,
I don't
you'll have your
think-
chance in the
I
second
don't
round.
think this statement is necessary at all. No, the reading material is some excerpt from certain books. Some thoughts come in the course of how do you explain internal sovereignty? How do you explain certain? I thought if they are useful, I can certainly.
One last word, and then we'll rise, of course, then we'll think of all that you've argued for the holiday tomorrow. That the wide chasm between absolute autonomy as it existed on the 26th of January 1950, all right, and complete integration as it was brought about on 5th of August 2019, that chasm had been substantially bridged by what was happening in between. So really, in the sense, it was not a complete migration from absolute autonomy to absolute integration.
it had become a shell, my lord, as
Whether you call it a shell or not, it's
Gujari Lal Nanda said. my lord,
it's
on the
obvious
shell.
that a substantial degree of integration had already taken place in the last, between 1950 and 2009, 69 years.
Final
And therefore,
point.
what was done in 2019, was it really a logical step forward to achieve that integration?
Absolutely.
Integration was whole already. In 1950, only assimilation was there.
different meaning for us. The power to make the law.
We have interesting issues, yes. We have interesting issues. Mr. Attorney, about how long would you take? About half an hour or so
An hour
now?
more if possible.
Sorry?
Maybe an hour more.
After that, Mr. Dwivedi will.
Right.
लोकतंत्र की परिकल्पना सबसे पहले भारत भूमि पर ही साकार हुई थी। लोकतंत्र में सरकारें चुनने का अधिकार केवल जनता का होता है और भारत के लोकतंत्र का जो दुनिया में विशेष स्थान है, उसकी ये पहचान और लोकतंत्र की शान दुनिया को चमत्कृत करती रहती है। इसी कड़ी में महत्व